implication ng decision na yan? What does it really say?
So the decision is really about jurisdiction. So in contrast to previous pronouncements about jurisdiction, which touched on it a bit and were also preliminary, this one really wrestled with the jurisdiction of the court, in particular the exercise of jurisdiction. So if we remember, the defense's challenge wasn't really that jurisdiction existed or exists in this case, because it does, because the crimes were committed at the time that the Philippines was a party to the Rome Statute. The challenge was, even having that jurisdiction, the court could no longer exercise that jurisdiction, because in the Rome Statute there are preconditions to the exercise of jurisdiction, and that it could be one of two. The one is the party, it happened in the territory of a state party, or it was committed by a national of a state party, both of which are no longer true past 2019 because we were no longer. So that was the challenge. This one resolved that challenge directly and said that the ICC can still exercise its jurisdiction over, in this case, former President Duterte, because this, while the authorization dun sa investigation happened in 2021 after our withdrawal, the preliminary examination, one that the prosecutor had commenced before we withdrew, which was in 2018, or the withdrawal became effective. So this is an on-point discussion on jurisdiction. So whereas before we had some doubts about the status, now the status is clear that there is jurisdiction. Of course, this is going to be, I anticipate that this is going to be appealed by the defense.
Appeal dahil what stage are we in again?
We are
pre-trial ba to ang tawag nila? Chamber?
roughly equivalent. So this is the confirmation of charges stage. But as in any trial, there are preliminary issues, and one of them is jurisdiction. But any or almost all rulings of the pre-trial chamber, any chamber, can be appealed to the appeals chamber, especially if they are questions of law. So
pareho ba yung resolution ng issue na to with yung principles ng Pangilinan? In the sense na, di ba, kasi parang iba with the way you were explaining it. Kasi Pangilinan says, yung kaso po ng Pangilinan versus Cayetano, parang ang sinasabi doon, that we still have jurisdiction, the ICC will still have jurisdiction over offenses or acts na commit while we were a member. Is that what you said? Parang iba
Sa first layer pareho, kasi yun nga, no, yung iba yung konsepto ng meron kang jurisdiction versus can you exercise that jurisdiction. So on that front, yun yung parang preliminary challenge ng Philippine government. It goes into meron ka bang jurisdiction at all, which was also resolved in that Article 15 in 2021 decision by the pre-trial chamber. Ito, yung tenor niya ay, okay, yung defense, sabi niya, hindi na namin i-question na meron kang jurisdiction kasi nga nangyaring nga naman yung crimes when you were a party. The question is, kaya mo pa bang i-exercise yan na hindi na party? So yun yung tinutumbok noong defense, at yun yung sinagot ng pre-trial chamber na yes, we can still exercise this.
Dahil nga nagsimula na yung investigation?
Oo. So, ang crucial language dito, Prof. Dan, ay yung nasa Article 1272 na dinownplay ng defense sa kanyang challenge. No? So, the 1272 kasi says that a withdrawal shall not prejudice the continued consideration of a matter already under consideration by the court before the withdrawal. So, maraming aspeto ng language na yan ang kinontest, pinagdebatihan ng defense at ng prosecution. In the main, sabi ng defense, hindi nga actually relevant itong 1272. Ang relevant ay yung Article 12 which sets out the conditions. Pero on 1272, yun yung focus ng decision ng pretrial chamber. Sabi niya, ano kasi to, no? Parang, actually, ang interesting sa discussion, so meron siyang discussion on ordinary plain meaning nung words na yan. No? Ano ba yung matter under consideration by the court?
Right.
So, because of its breadth, the ordinary meaning of those terms mean any matter under consideration, whether it was by the prosecutor under preliminary examination or whether it became a case already. But I think the interesting part of the decision also was how the sequence of events. So the pretrial chamber acknowledged that right after or a few months after inannounce ng ICC ng prosecutor na merong preliminary examination yung office niya dito sa kaso ng Pilipinas or sa situation ng Pilipinas, I think a month or two after, nag-withdraw tayo from the Rome Statute. So, parang bumalik siya doon sa ano ba yung object and purpose ng Rome Statute at this particular language. No, ito yung parang hindi ka makakatakas sa accountability, walang impunity dahil hindi mo matatakasan yung investigasyon by virtue of a withdrawal. So parang to the chamber, that sequence of events showed that this was a device to escape that investigation, withdrawal. And so the Rome Statute balances that interest with the sovereignty of the state by putting in exactly this provision.
Okay. So malamang appeal and marami bang appeal process to? Parang every time may ma-resolve na question, appeal. And
Yes.
how long will this take?
They've gotten better. So you're right first that parang lahat ng questions of law halos ina-appeal. It really comes with the nature of the institution. Wala kasi siyang president. So parang every time you raise a question, it's a new question. Kasi walang, although they can draw upon previous resolutions.
Cases.
Oo, but hindi siya parang yung common law concept na controlling yung case na yon. So that's one. The other is, before matagal talaga siya kasi ang puno yung docket ng court and sila din naman yung nire-reshuffle. Ngayon, mas mabilis. In fact, I expected that they'd take longer for this jurisdiction question. So the challenge was posed in May. And now it's resolved. So a matter of months. I mean, siguro by someone's standards, this is still a long time. But by ICC standards, where trial could take years and years, this is already fast.
Pretty
so
fast.
And because nga of the reduced, kasi wala masyadong nasa docket ngayon. I think that's a testament to maybe the ICC working na wala masyadong international crimes na nangyayari. Except the really big ones that we know of today. So I would anticipate it in a matter of months also, within the same timeline. Depende kung kailan nila ipa-file yung kanilang appeal.
Meron pa bang ibang argument na pwedeng i-raise ang defense? Kasi that's all I've been seeing. Like, they've been called dilatory tactics daw, di ba? Whether that's true or not. Do you expect the council to throw other arguments?
I think meron pa silang, in fact, they attempted it here. Kasi merong question on competence right now, di ba, yung fitness to stand trial because of all the health concerns. So the defense tried to argue that question should be resolved first. Kasi if the chamber finds that he is unfit to stand trial, then that's it, right? I mean, he won't be subjected to further proceedings. So the chamber said I think, and then this is, and every law student will understand that the question on jurisdiction should be resolved first. So that's what the chamber said. But that issue is also pending, the fitness to stand trial, and I assume that they will also raise that, and how it was sidelined by the pretrial chamber when they appeal to the appeals chamber. Um, I think there, in terms of novelty, wala masyadong bagong, kasi yung defense challenge, if you remember, yung authorization to investigate sa 2021, inappeal din yon sa appeals chamber, which was resolved in 2023. So sabi ng appeals chamber, hindi na properly raised yung question of jurisdiction, so inaffirm niya yung pre-trial chamber. But there were two dissenting judges there who discussed the issue of jurisdiction head-on and said, walang jurisdiction kasi nga, ang paningin nila, it should be when the investigation was authorized. Yun yung exercise timeline. And that happened in 2021. So that was raised already by the defense in this second round of jurisdictional challenge. Hindi siya in-engage masyado ng pre-trial chamber kasi parang nag-focus talaga siya dun sa textual analysis. Whereas parang yung tone ng argument ng defense doon ay yung parang sovereignty question. Talaga na parang pwede pala yon na nag-withdraw na yung state, madidefeat yung kanyang sovereign prerogative not to consent to a regime by virtue of this parang maneuvering of the language. So I think they will reframe that argument in the appeals chamber to speak to the dissent in the previous one. But I think, at least from my point of view, I'm less nervous about that argument kasi parang even the dissent of the appeals chamber then was also engaged with by the pre-trial chamber. So,
All right. So, all these issues can run independently of each other. In other words, yung jurisdictional issue was resolved while pending yung kanyang fitness, di ba, yung question ng fitness ng defendant na ba siya or hindi pa naman?
accused na siya.
Accused na siya. So the other question I have is, kung hindi nga siya fit for trial, will he be released?
Yes. Kasi wala na at all mangyayari na proceeding. Kasi in fact, that's one of the purposes of the confirmation of charges. So the main question in the confirmation of charges is still the evidence. But part of the question is it still fruitful, or do we still hold a trial given the evidence and all other circumstances? So if it's a circumstance that he won't understand what will happen in that trial, then the chamber will likely say, well, there's no point in holding a trial because the rights of the accused would be paramount.
So yung fitness is not the same as insanity, kumbaga yung sa atin here in the Philippines, di ba? So lack of fitness can be a lot of things. Is that what you're saying?
Yes. So actually mas mababa siya, kasama yung insanity pa rin. So if you can plead insanity then and you can prove it, then you, in the same way, you won't understand what's happening. Pero mas mababa yung mababa in some sense, mataas yung standard, which is may exercise mo ba yung mga karapatan mo bilang akusado dito sa trial. Hindi kailangan ma-exercise mo at their notional highest, right? So yung giving advice to counsel, you're not required to be at your peak for you to be considered fit to stand trial. Pero meaningfully, may exercise mo ba? So even if you have an affliction, no, meron kang health condition, but you can understand what is happening.
Ito yung comment ni Donsky, and I've seen this in a few movies. Kung maarte ka lang, I remember oh my God, si Richard Gere. Anyway, naloko siya ng kliyente niya because the client was pretending not to understand yung circumstances. Pwede ba yung mangyari in real life?
Pwede. I think tinry din yan ng iba before. Pero ito kasi, so ang mangyayari ay merong experts na mag-i-evaluate. And yung practice ay tatlo, usually. Iba't iba yung fields. Merong psychiatrist, psychologist. So, they will really evaluate and scientists sila. So, they'll make their conclusions or findings on the basis of their own methods. So, there will be an independent evaluation. So, I think mas likely na dahil hindi babad yung judges in this field, baka mas mauto yung lawyers. Pero I think mas mahirap lokohin yung experts talaga dito. So, and they're a committee, usually. May ibang beses isa lang. Pero even then, competent pa rin itong mga experts na ito. So it's really going to be a clinical examination. So, I think in that sense, mahirap siyang i-feign. Now, the question is, ganun ba kagaling na actor si former president? I think we know that he goes off script.
Yun na nga
In many
That's his
cases.
problem, di ba?
So, ma-distract lang siya ng konti. That might reveal something. So, if it's possible, it's possible, but unlikely for me na he's good enough to convince everybody.
Ilan ba?
Na
I hear the experts have been selected.
parang tatlo yata, sir.
Tatlo.
Yeah.
Do they have to make a unanimous decision or ano ba to, majority wins?
No. So it can happen that all three of them have different evaluations. So there's hindi siya yung parang commissioner sa ating rules of procedure na kailangan na may dissent, ganon. I think they can all make independent evaluations. They can also submit a consolidated report if they agree on all the conclusions. But it still rests with the court. It's still a judicial function to find whether he is fit or unfit. So what they make of three different reports or one consolidated report will still have to be tested against the standard of, is there a meaningful way for him to exercise his rights here? So may mga kaso tayo na may mga temporary loss of memory, but because there are instances when that memory is recalled or is regained, okay lang yun. He is fit to stand trial. So I think medyo mataas in that sense, mataas yung kailangan mong i-satisfy to be able to say na hindi mo talaga naiintindihan yung nangyayari and can't act accordingly.
All right. Okay, first of all, the movie is Primal Fear. Thank you kay Reggie Duran. Richard Gere, Edward Norton. Tapos may mga comments earlier about para ka daw nasa seminarista.
Oo, Friar. At Gomborza na
Nakita ko pala yun.
Gomborza.
Tapos, okay. Ano ba yung question ko? Nakalimutan ko na naman. Hindi ba dapat periodic yung examination to see if you can stand trial? Parang, if you release him right away, yung parang okay naman siya, isn't that something we should be guarding against?
Yes, sir. That is very true. Thank you for raising that. Kasi, yun yung process. No? So, yung process is, periodic nga siya. Suspension, I think, 120 days or 90 days every so often.
Okay.
Someone can request that the proceeding, kasi that's the nature of the affliction also, right? Parang, you can deteriorate along the way. So there will be periodic, or if the defense, which they're likely to do, will request it, the court can suspend proceedings at certain points and ask an evaluation again. So I think for purposes of today, because they postponed the confirmation of charges, then the evaluation has to be conducted for that to even proceed, to understand what's going to happen there. So there will be one at the very least, and that's the one that's pending right now.
Give us a picture of what's going to happen in your view, no? Na resolving jurisdiction, that was probably going to go on appeal, as you said. And if that is affirmed, game na yung trial, except for the issue ng fitness to stand trial. Or are there other surprises that we should look out for?
Um, so the confirmation of charges is an avenue for surprises. So because so that's the parang stopgap measure here. So they don't have this arraignment um, uh, process, but they do. Kasi the ICC, I think part of it is the purpose really is to focus on the most responsible. Kasi in many of these cases, thousands yung perpetrators, like in war crimes, for example.
Right.
And the other thing is they have limited resources and limited time, so they focus on the parang architects, the masterminds of the international crimes. So that is a parang purpose for the confirmation of charges, so that they don't spend years and years on a trial tapos parang marginal yung effect niya on the whole dun sa crime. So so yun yung purpose ng confirmation of charges, and that can spell a win or a loss here, because if the pretrial chamber doesn't find na may sufficient evidence here to proceed to a trial, they can stop there. So even if they resolve that parang fit siya to stand trial, but they find the evidence insufficient, then no trial will happen. They will not confirm
But they will
the
make that
charges.
determination before the evidence is presented?
They will present a sampling of the evidence. So mas mababa yung, so whereas in trial we all know the standard is guilt beyond reasonable doubt. Here parang yung to proceed to trial, you have to satisfy yung sufficient evidence to establish substantial grounds to believe that he committed this crime. So mas mababa siya, mas mataas siya than yung investigation threshold, pero mas mababa siya than the trial threshold. So I think with the kind of evidence that we have in this case, sobrang bungled ng prosecution if that even happens, na hindi matutuloy yung trial. But also it depends on what they present, no? We also don't have a view yet, apart from some general statements about this was just a president loving his country, things like that. We haven't heard the actual legal defenses of apart from yung mental condition na yun, no? So we don't know the strength yet of that defense. Also, because this is a sampling of the evidence, we also don't know what will be presented by the prosecution. We have an idea that perhaps it will highlight the clearest cases of that you can attribute the killing, for example, to the masterminds of the so-called war on drugs. Perhaps it will present witnesses. I think we have someone under witness protection as a quote unquote whistleblower here of that war on drugs. So that sampling we don't know yet, but we have an idea of what it could be. So there might be, so because I think we've already been exposed, the thing to understand is really the ICC can be very surgical about how they apply certain standards. They are mindful of their status as an institution, legitimacy questions, and the state. So they will be very surgical about how they apply standards. And so that can be, and some people might perceive that as boring when you watch ICC proceedings. But so the prosecution really has to do a good job of satisfying that standard, which I think it's not very hard here because sufficient evidence lang naman yung hinihingi to show. So but even then, we can still have surprises in the confirmation. Like for example, just a test, no, parang meron tayong naririnig na china-challenge ng defense yung credibility ng some of the witnesses. So they can paint that picture in the confirmation of charges. So if ma-challenge yung credibility and the pretrial chamber is convinced, then that's one strike against the prosecution. So there are things like that I think as we go along and the confirmation of charges plays out, we will need to talk about so that your viewers in particular, Prof. Dan and Prof. Shelo will understand. Because a lot of it is not how we do it in the Philippines.
And since we don't have a lot of kumaga case law, hindi ako pwedeng magalit if I disagree, no? Kasi walang precedent. Most of this will be defined for the first time.
Hindi naman, kasi tulad nitong decision on jurisdiction, you have the text. So yun naman ang maaasahan mo dito sa ICC and many other international institutions. Kasi nga, parang they're mindful na they're not overstepping. They really hew to the text of their charter. So any lawyer, any person can read that text and have a sense of the ordinary meaning of the word. So pwede ka pa rin magalit. And then of course you have this entire this is under the entire project of wala dapat impunity for international crime. So everything has to track that purpose of the Rome Statute. So ang makaka-defeat lang siguro nun ay kung bina-violate yung rights of the accused, which is also a value that they hold dear in this institution.
All right.